you, but don't mislead the public. We do not say gag the member, but you read the provision 115. Please, this is an opportunity for many to learn, and many of our citizens are listening to us. I want to read it carefully. 115. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. So, as I preside here, I can question your freedom of speech applying the rules, but I cannot go out of Parliament to question it or go to court to question it. But here in session, that freedom is open to question or to impeachment. Please, the rules are clear even in our standard. Don't mislead the public. You may go on.
Thank you, Mr. Speaker. Mr. Speaker, the point I am making is that on our side, we believe that one arm of government is controlling another arm of government. And in this case, the executive is controlling the judiciary. By this act, Mr. Speaker, the act of where there is the head of judiciary, that judiciary is removed, and that has not been exhausted. And another, these matters are pending before various courts. There are 7 cases that are pending, Mr. Speaker. I can go ahead and then mention them. Mr. Speaker, amongst other things.
Please, I'm taking this of your time. The majority leader is on his feet. Please, what is the issue? I've taken note of your time, please. Yes.
Mr. Speaker, our standing orders in Order 1, 2, 3 clearly prescribes the content of a speech. And 1, 2, 3, 2 says that a member shall not use offensive, abusive, insulting, blasphemous, or unbecoming Mr. Speaker, for a member to say on the floor that the president is controlling the judiciary, when the president has sworn an oath before this House to uphold and defend the Constitution, and the Constitution does not make provision for the president to control the judiciary. So when you stand in this House and say that the president is controlling the judiciary, you are clearly including the integrity of the president. So, Mr. Speaker, Mr. Speaker, I therefore think that that should be struck out of the records of this House.
Honorable members, the member has expressed his opinion. And in expressing his opinion, the member Honorable members, just a few days ago, I talked about the clapping of hands. That is not part of the practice of this House. You can heckle your colleague, but don't use your hand and the clap. It's not. Please, I identify the person who was doing that. But at least for today, you will be pardoned. Next time, I will not do so. Honorable members, please, let me repeat. The member expressed his opinion, and in expressing his opinion, he never used any offensive, abusive, insulting, blasphemous, or unbecoming words on the executive or any other person. So he's entitled to express his opinion. Once he has not used any such word, I think he's in order and he should continue.
Yeah, thank you, Mr. Speaker, for my protection, for your protection. I'm grateful. Mr. Speaker, there are serious cases pending before the courts. There is a matter of the Mr. Speaker, if I may make a small reference. There is this case of the Chief Justice Gertrude Togono versus Article 146.
Honorable member, please. Honorable member, you can't take us back. I pronounce on this matter. Why? Please, minority leader, may you kindly allow the very competent honorable member to continue with submissions. I am very observant, and I have watched you, and I've seen and even heard some of the things you are whispering to me. That is not allowed. Please, he is competent enough. I am very vigilant. Please. Yes.
Mr. Speaker, with respect. Mr. Speaker, with respect. The respected Dominic Nicky is here. All we are telling him is to focus and abide by your direction. Please, Mr. Speaker.
Minority leader. Honorable minority leader, you are facing your colleagues. You are facing your colleagues in the majority, and also the part of the public gallery behind them. Please, honorable member, yes, go on with your submission. Please, you are now left with 2 minutes. 2 minutes.
Mr. Speaker, it is common knowledge that, and it's our belief, that this constitution, the very constitution that we are protecting and guarding against, is being breached because there was no prima facie case made against the former Chief Justice, and the matter still remains in court. Mr. Speaker, the matter still remains in court, and that has not been dispensed with. Mr. Speaker, other applications have been filed for sectoral rights. The decisions that have been made must be quashed. Again, those decisions,
Please. You can't litigate that case before Parliament. You can't. This is not the forum for that. Please, if you go that way again, I'll apply the rules. You know the rules. Please.
Yeah, Mr. Speaker, we also want Kenyans to know, and I cited the private facie case, and nobody knows it in Ghana. We are, Mr. Speaker, there reports that we are told that there were 3 petitions against the former Chief Justice, and we heard of one. The report of the committee, Mr. Speaker, remains unpublished. We don't even know what went into that. And we believe that as Ghanaians, before we get to today, we must know the details of why there is vacancy in Ghana that we need to fill. All we are saying that this arm of government and the head of that arm of government, which is judiciary, Mr. Speaker, that seat is not vacant. And even if an attempt has been made to make it vacant, that attempt, Mr. Speaker, we cannot see through that. We think that it's faulted, that is.
Honorable members, the honorable member has finished with the submission. The time is up. And honorable members, I direct that all what he said after my last ruling are expunged from the record. A number of times drawn his attention that this is not the forum for the litigation of those cases. What we are considering now is the appointment of a nominee. That nominee has been taken through the process of public hearing. You had the opportunity to appear before the committee and to put across all what you just alleged. You opted to boycott. It is now not for you to come through the back door and be making allegations. Hearsay evidence is not admissible here. Please, let's move on. We now will listen to, from the majority side, whether they also want me to go by the order that is numbered, and therefore from the majority side, they started with the backbenchers, and the first backbencher is Honorable Zuwera Ibrahima.
Thank you very much, Right Honorable Speaker, for this opportunity to look at the report of the Appointments Committee with regards to the nomination of the Chief Justice nominee of the Republic of Ghana. Mr. Speaker, I want to make this preliminary statement that I actually had an opportunity and privilege to sit through the entire vetting process. His background, any day, is worth celebrating. And Mr. Speaker, as I sat in the vetting session and listened to my Lord Justice Paul Bafuboni, I was convinced that he was the best suited for the position at this time. Mr. Speaker, my lordship was nominated to the Supreme Court in January 2008. He spent 17 years at the Supreme Court. And Mr. Speaker, even at home, we all have this adage that we say, experience is the best teacher. After 17 years, Justice Paul Bafuboni demonstrated at vet that this country and the judicial system of this country is going into very safe hands. I say this because as a woman, Mr. Speaker, and a champion of women leadership, I want to celebrate all the women chief justices that we've had. We had Her Lordship Georgina Wood, who was appointed to the Supreme Court in 2002 and became Chief Justice in 2007. She reigned for 10 years, and we all saw the output of her work. It was not in question. Her capabilities were never in question. Mr. Speaker, we saw Her Lordship Sophia Akufu, who had spent 22 years at the Supreme Court before becoming a Chief Justice in 2017. Mr. Speaker, she exited the role with impeccable credentials. Mr. Speaker, again, let me say this to this House, and I want it on record. Again, I had the opportunity to be a member of the vetting committee, appointments committee that vetted her ladyship, Tokono. Mr. Speaker, I recall I asked one question. I asked my lordship, what are the attributes of a good chief justice? Give me 5 attributes. She gave one. Mr. Speaker, the Saturday after that vetting, a former member of this House, a leading member of this House, Honorable A.B. Hussein, was on Joy News 5 discussing the vetting of Her Lordship. And he said,
Minority Leader. Please, honorable members, may we have your ears. Deputy Minority Leader. Please, honorable members, please. I heard her say that as a woman, she was going to celebrate women that were chief justices, and started with Her Lordship Justice Georgina Wood, and said so many things about her. I practiced before her when she was High Court judge. I know her very well. Then she proceeded to Justice Sofia Akufu. She was in practice, private practice, when I was also practicing. So I know her very well. Now she proceeded to Justice Toku. She is far behind me, so when I was in flight, she was not available. She was saying what happened. Please, she was. I have to relate to this before I give my ruling. She was sharing her experience when she appeared at the appointments committee, and that she member speaking was a member of the appointments committee, and she asked her a question about the five attributes of a chief justice. And now she's going through what took place. So I was keenly listening to her to see whether she will pass the acid test of our rules. That is why I'm following her keenly. If she doesn't, I'll call her to order. Please, I'm listening. I will not allow her to say anything that is unparliamentary about the former Chief Justice. Please. Yes. Honorable Member, you are left with 1 minute, 30 seconds.
You guys will take care of this thing come for us tomorrow. So me, if I can, I'll not be getting.
Thank you very much.
Why?
Right, Honorable Speaker. So, right, Honorable Speaker.
If we're not the what?
I left. So this is the experience with.
Why you push your own people one side?
Get to Arabato. To the extent that the former member of Parliament, Honorable ABS, had occasion to speak on Joy News 5 on a Saturday, and said that in his opinion, the most important question that was asked that day was the question asked by Honorable Suera Mohammed. Chief Justice nominee failed to answer that question. Now, Mr. Speaker, I'm making this point in order that I can go
you rightly stated. That is the opinion of Honorable A.B.A. Hussein. As to the marks you are giving to her answer, it is not for you to be satisfied with her answer. Once you ask the question, even on the floor here, the answers that are given does not necessarily satisfy the people who ask the questions. You cannot use that as the basis to judge her on this particular situation where she is not in question. We are not here discussing the former Chief Justice. No. So if you are going to celebrate them, and let's move on. Please. Yes,
Thank you very much, Mr. Speaker. Mr. Speaker, I'm guiding.
Mr. Speaker, Mr. Speaker, that tells us what they are not listening to you. Because you have not informed me.
Please go on.
Mr. Speaker, thank you very much. Mr. Speaker, I want to really thank you. People who are not here to defend themselves, as Mr. Speaker has said, if you want to say adverse things about them, Mr. Speaker, I want to please, as you have done, you protect them. So I want to say to you, Mr. Speaker, I also want to say, Mr. Speaker, that I call on you to let them expunge that particular section so that it does not stay in the handle. The section, the point she just made in trying to give marks to somebody who is not here, and even she is the subject of all that we are doing, they should expunge it. Because if there's anything, the record is that she has been our chief justice before. And she has cases before, we don't know what will happen. So they should expunge that portion from the handle.
I'm trying to get which portion, because please, what I said was that she referred to the opinion expressed by ABA Hussein, showing that they were not satisfied with her performance. And I said that is his opinion. So, is that what you are saying? I will get a point.
Okay, thank you, Mr. Speaker. Mr. Speaker, the point I'm making, the entire section should refer to the former, the Chief Justice, or Justice Tokonu's vetting, where she says that she failed to answer questions. I think that we should respond to that. That's the point I'm making. We should respond to that. Just as you admonish, and you admonish that I should bear away from it, I'm going further to plead with you to let the hazard expunge that section of prison from the record. Because unless somebody reads your comments, if I'm reading the hazard and I don't go further to read your comments, I will not know that you are trying to move away from it, and that it's not good. I just want them to expunge that section. That's all that I'm saying. The section that goes to say that she has failed those questions. She should expunge it. That's all I'm saying.
Honorable member, I want to hear you again, because if I had heard the use of the word she, I would have definitely ruled her out of order. What did you say?
Thank you very much, Right Honorable Speaker, for the opportunity to correct this. Mr. Speaker, I asked a question to the then nominee, asking her to give 5 attributes of a good Chief Justice, and she mentioned 1. Thereafter, the Saturday after the vet, Honorable ABA Hussein was on Joy News Newsfile program discussing the entire vetting process, and he indicated that he thought that the most important question that was asked at attributes of a good Chief Justice. That is what I said. I never use the word fail. My weakness, they can hold that weakness. The word fail never hold this.
Listen to her, and so I'll proceed to direct that if she had earlier used the word fail, that portion be deleted from the official report, particularly the word fail. Now she has stated clearly she did not use it, but it's recorded, and so the official reports will go through all this. If they come across the use of the word fail and the words after it should be deleted from the official reports. Please, now you have 1 minute.
Thank you very much, Mr. Speaker. Mr. Speaker, in conclusion, and tying it all into my previous statements, Justice Bafomoni made very strong statements against it. And one of the things he said that drives my enthusiasm today, and I quote, he said, the Constitution of Ghana entrusts the Chief Justice with a dual responsibility to adjudicate cases with fairness and to safeguard the credibility and moral authority of justice itself. Mr. Speaker, it gives all of us comfort. Mr. Speaker, as I said, I watched Justice Bafomoni. He spoke from his heart. This is a man who was ready to leave a job at the prison service so he could marry his sweetheart. And he was advancing with Mrs. Bafomoni. Mr. Speaker, it tells you the character of the man.
May we now listen to Honorable Anthony Emia. 5 minutes. 5 minutes. 5 minutes.
Thank you, Mr. Speaker. Mr. Speaker, may I place on record that Gertrude Tokono, throughout her distinguished service as a judge and Chief Justice, had an impeccable record. Not just impeccable, Lord, Mr. Speaker, sorry. It was also spotless. Unfortunately, we did not give her the chance to exhaust a full term as Chief Justice of the Republic of Ghana. Mr. Speaker, the executive summary before me this afternoon makes capital out of Article 144 of the 1992 Constitution, which has given birth to this exercise and the said reports. But in the view of the minority, the said article has been invoked prematurely. And I said so based on arguments advanced by my colleague, Honorable Animedu, citing the various cases. What is interesting about the said cases, Mr. Speaker, is that
Honorable member, don't fall into the same trap. That is not before us. And you know that these are matters pending in the court. So you have the right forum to go and ventilate your grievances and as much as possible vindicate yourself at that forum, not in Parliament. Let's proceed with the business before us. That's all.
I am very grateful, Mr. Speaker. Mr. Speaker, I will dwell on our own rules from our standing orders, particularly orders 103 F, 1231, 217, Rule 2, as well as 216, Rule 4, in further proceeding with my comment on the report. And with your kind permission, I would want to read the various orders. Mr. Speaker, Order 103 F says, a motion shall not relate to a definite issue, and a motion shall relate to a definite issue and not F be the subject matter of an action on which a judicial decision is pending in which, in such a way as may, in the opinion of the Speaker, prejudice the interests of the parties to the action. When you move on to 1231, 1231, which is under content of speech, says, a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way, or may, in the opinion of the person presiding, prejudice the interests of the parties in the action. The combined effect of Order 103F and 1231 with a bit of respect is to prohibit reference to parliamentary proceedings that prejudice cases before the court. But in this particular instance, that is exactly what has preceded events leading to today's report. I will not. From what
please, honorable members, don't temper on the mic. You may go on.
Then again, if you move to Order 2172 and Order 2164, part of our own rules, and Mr. Speaker, again I seek your permission to read Order 2172, which says the chairperson and ranking member and two other members of relevant subject matters pending or select committee shall join the consider persons nominated by the President for appointment as Chief Justice and Justice of the Superior Courts, Ministers of State, Deputy Ministers, Administrator of the District Assembly Common Fund, the Special Prosecutor and other persons specified under the Constitution or any other enactment. The 2164 stipulates that the clerk is responsible for arranging questions admitted by the Speaker to conform with the rota and to inform the ministers accordingly. From my understanding, the combined effect of 2164 and 2172 is that 1. There was no lawful vacancy that is flowing directly from 2172.
Honorable member, out of order. Please, your time is up. And we proceed to the next person. Honorable members, we will now listen to Honorable Muntaka Mohammed. 5 minutes. 5 minutes. Honorable members, the timing has been captured by the recordings. The instruments will give 5 minutes exactly. So when it gets to the 5 minutes, it will cut off automatically. That is what happened to the honorable member. And so I had to give him extra minutes. So please, Honorable Muntaka Mohammed, Minister for Interior, take note.
Thank you, Mr. Speaker. Mr. Speaker, I want to thank you for the opportunity, but to remind the House that, Mr. Speaker, I'm not a backbencher. Because I heard earlier, Honorable Ayimadu was given 10 minutes. And I thought, Mr. Speaker, I don't know how the rest will came, but the most important thing is that ministers are equated in rankings and chairs. So I don't know if that timing will be relooked at. But
you are actually not a backbencher, but you have been favored to speak instead of a backbencher. That you have been given to a backbencher. So I thought that you should have shown some gratitude to your leaders. If you think that you are oversized, then we'll get proper size for you next time.
Well, I'll thank you and the leadership for the opportunity to speak in place of a backbencher. But my worry is about the conclusion of the report of the committee. The Speaker, as you may know, the House is guided by rules. And all our rules, the Speaker, because of timing, I want to say that if you take order 217, it says that the committee's report will either be by consensus or by voting. The Speaker, as far as all of us are concerned, there was no voting at the appointment committee. Because the Speaker, as you know, votings are done at the tail end of the matter, whether it's a motion, whether it's a question, whatever decision is taken at the tail end. And the Speaker, as we all also know, because of the timing, the rules of the House say that whatever rules that play in the chamber equally plays at the committee level. And the Speaker, like I'm debating now, I cannot sit down and remind, tell you, Mr. Speaker, when it's time for voting, I'll be voting this way and therefore step out. No, it has to be, I have to be present and be voting, as in Article 104 of our Constitution and our standing orders 159. Mr. Speaker, I believe that the committee's conclusion should be done. It is by consensus decision. It cannot be by majority decision. It was by consensus decision. Mr. Speaker, and the most important thing, as Mr. Speaker, you may know because of your deep knowledge of this House and its rules, if we are as a committee to vote, until somebody raises quorum is assumed. If it's time for us to vote, and there's nobody to raise issue of whether we have our full membership or what have you, it is assumed. Because when people walk out, their names will still be recorded as present. Once you record those who are present, their names will be recorded. But they cannot say, we are voting, but we are walking out. No. The time that they were saying they were voting was not time for voting. So, Mr. Speaker, I want the House to consider this and amend the committee's report to indicate that the decision was by consensus. So that Mr. Speaker, most importantly on the nominee, for me, I'm wondering why our colleagues are even what they are doing. Because, Mr. Speaker, it is very clear by Article 146 of the Constitution where the President is mandated in their petition to remove a chief justice or otherwise, the proper procedure will follow to the end. And if you have a challenge to that, it is not on the floor of Parliament that you can challenge that. So, Speaker, the nominee, if you look at his experience, you and I, Mr. Speaker, with all humility, were members of the appointment committee when we started in 2008. I was a bank member of the appointment committee, and he's been there for 17 years. So, Speaker, if you look at his impeccable record, you will be wondering why has he not been Chief Justice long ago. Because Speaker, this is one person that has run his career through almost all the governments. He got to the bench through President Rawlings, as indicated by even the committee's report. He got to the High Court through President Rawlings. Then, through President Kufuor, he went to the Appeals Court and the Supreme Court. And he's one of the very experienced presidents. We have to look at his experience, if you look at the things that he's able to do, even academically. And you wonder why he was not even made a Chief Justice earlier. But as we said, everybody marks his time. This is his time. This is the time for justice for Babylon. We must support him and encourage him to be able to give out his best, as he himself has indicated in the record. But Mr. Speaker, I want us to look at the issue of the committee's conclusion, saying that it's a majority decision. Mr. Speaker, I strongly believe it is, but
very difficult to accede to your request because you now have to define what voting means. What do you mean by voting? You have to use a thumbprint. Can you use your mouth to vote? There are so many ways that you can determine somebody has voted. The report is very clear. It says after the minority leader made his submission, which was preliminary, it stated clearly and it's quoted, the minority caucus hereby votes en bloc to reject the nominee. That is at the public hearing. And so, clear indication as to voting. Then, getting to the end of the report, the chairman captured it again, where he says in conclusion, all the members of the New Patriotic Party minority were opposed to and voted against the nomination of the Chief Justice. That is what we have. And so I'm saying that then you have to define what you mean by vote. Is it going to be a physical indication either by tongue or pen, or could it be by word? And that one, we may have to look at it again. Then he concluded, the chairman, the committee therefore recommends to the House by majority decision. He didn't tell us how the majority came by a decision. And it could be just the discussion there that they agreed that we support the nomination. That will be a decision, and that will be a way of voting. And so once they took that decision and adopted the report, we cannot question that they haven't been voting at the committee level. That is the challenge I have. And so I'll have difficulty in directing that the report of the committee be amended to capture the views that we've expressed. May we now go on to the next person, and that is the Honorable Member for Tapuli Alasan. Tampuli Hassan. Your constituency is Bushebu. Bushebu. That is his name here. Yes, please.
I'm sorry, the Speaker will respect. I submitted the names from the minority. And as far as I can recollect, the next to speak is the Honorable Samir, Guy Jude, and Dodge. That's the least. No, that's the least.
Well, that is what I have here. But when your leader was speaking, he mentioned Tampuli before. But what you actually submitted to me, the third name is Sami Anku. Only 5 minutes. But in his submission, he mentioned Tampuli first.
I would respect, not to challenge the leader, but we will respectfully reply of you that will go by the list. So we will.
The Honorable Sami Anku, 5 minutes.
Honorable Speaker, let me thank you for the opportunity to comment on the Appointment Committee's report on the President's nominee for the office of Chief Justice.
Are you contributing to it or you are commenting?
I'm contributing to the right Honorable Speaker.
Well, the two are different. The two are different. If you are going to comment, I will take note of that. If you say you are going to contribute, then I take note.
Honorable Speaker, I'm contributing.
You may go.
Mr. Speaker, I listened to the President Speaker as he eloquently also touted the achievement of the President's nominee, including his diligence and competence. Mr. Speaker, this is a sharp departure from a previous position when Justice Bafuboni was nominated for the office of Supreme Court Judge under President. The NDC vehemently opposed the statement. Mr. Speaker, our position and that of the minority is not premised on personal grounds, but clearly on a matter of principle. Mr. Speaker, pursuant to Article 1446 of the Constitution, it is clear that the judiciary currently is for leaders. The acting Chief Justice enjoys the powers of exercising his discretion and also the administration of justice. So, Speaker, what may likely create some genuine crisis in the minds of people will be the invitation of Parliament in helping install a new Chief Justice and the court subsequently, if matters before it are resolved and move the other way. So, Speaker, for the avoidance of doubt, Article 144 mandates the President, and the President's power to also nominate a Chief Justice is not impaired at all, and it's not challenged. The President has exercised that power by nominating Justice Bafuboni. Parliament's approval function, like all other constitutional powers, must also be exercised consistently with other constitutional provisions. Right, Honorable Speaker, including the separation of powers, judicial independence, the sub judice rule, and also respect for pending processes. Right, Honorable Speaker, Justice Bafuboni has less than 2 years to retire. And we respectfully hold the view that this process must also not be rushed. And with all the benefits available to him and the powers available to him as acting Chief Justice, we believe the balance of convenience arguments really can hold sway here. And what is this balance of convenient arguments here? If justice for Bafokoni is approved by Parliament today, right, Honorable Speaker, and the ECOWAS Court or Supreme Court decides otherwise, Mr. Speaker, the Constitution does not give direction on how to deal with such matters under such circumstances. Mr. Speaker,
Please, Honorable Member, may you move from that and go to the next. You have other issues.
It is our considered position and we hold a duty and we complete fidelity to the law. And we believe that these processes, we can hold on with it and enjoy the process. And it's on this basis that we join the House and also call on the House as well to reject the
Thank you so much. You have within your 5 minutes. It was just there some seconds. Thank you so much for being generous. We now go to the next person, and that is from the majority side. Honorable Dominic Ayine, the Attorney General and Minister for Justice.
Thank you, Honorable Speaker, for the opportunity to contribute to the motion.
Honorable members, he's not speaking as a backbencher. He's speaking as a middle bencher.
Thank you, Honorable Speaker, for the opportunity to contribute.
Sorry. Yes. Honorable Hakim.
We said we're speaking as a middle bencher, but the agreement we have, middle benchers don't have 10 minutes, then you have 7 minutes. So Mr. Speaker, reminded that unless he's speaking on behalf of the leader, but if the Attorney General is speaking as a middle bencher, he has 7 minutes, not 10 minutes.
Honorable Member, you are right. But what they submitted, I can see they cancelled the Honorable Eric Okoku 10 minutes and they gave him 7 and rather gave Honorable Dominic Ayine 10 minutes. That's what I have here on the paper. So he is speaking for 10 minutes. Honorable Eric Okoku receiving 7 minutes. That's what they have done. Please.
Mr. Speaker, with respect, in our case, we did indicate that the minority chief whip, that is the chief and the whip, slot was given to Honorable Animedu. That was the reason or the basis for his 10 minutes. So if it is the case that one of the leadership from the majority front bench is ceding his position or his allocation to the Attorney General, then it should indicate so. Rather than that, none of the speakers, apart from the leaders, have 10 minutes to speak. So they should put that on the record. So that it will not be the case that leadership will also speak. And then
I have put that on the record. They don't need to do that. So please, let's move on. You have 10 minutes.
Right, Honorable Speaker, thank you very much for the opportunity to contribute to the motion for the approval of His Excellency the President's nomination for appointment as Chief Justice of the Republic of Ghana of the Honorable Justice Paul Bafokoni. Mr. Speaker, I have a preliminary observation to make. As was rightly pointed out by the Honorable Ibrahim, I also, the Honorable Member for Salaga South, I also sat through
and observed, sometimes with consternation, about the conduct that was exhibited at the vetting. Mr. Speaker, the Constitution enshrines the doctrine of the full equality of the three branches of government: the executive, the legislature, and the judiciary. The doctrine of co-equality means also implicitly that the principle of comity, and I'm talking about comity as in C-O-M-I-T-Y, must apply in the relationship among the three branches of government. What does comity mean? Comity, Mr. Speaker, simply means courtesy extended towards a person that you respect as a co-equal. Mr. Speaker, on that day,
Honorable member, you have 10 minutes.
yes, Mr. Speaker,
Unless you want to tell me, unless you want to tell me that the apology are rendered to the judiciary because of the conduct of some members at the Appointments Committee is not sufficient. Unless that's all you want to tell me, I think that you need to move away from where you are now to another issue. I have done that already on behalf of the whole House. And I did it sitting on this same chair, presiding over this House. So please, don't overstretch that issue again.
thank you very much, Honorable Speaker. I thought rightly that I was adding my voice to your powerful voice about how we conduct ourselves. So I take a cue from you. Mr. Speaker, we on this side of the House, we have no doubt that the President of the Republic appointed the right person to the position of Chief Justice of the Republic. Mr. Speaker, in line with Article 128 clause 4 of the Constitution, there are three main criteria for qualification as a justice of the Superior Court. One is high moral character, proving integrity, and that the person should be not less than 15 years experience as a lawyer. Mr. Speaker, the Honorable Chief Justice, the Honorable Paul Bako, more than qualifies within the context of Article 128 clause 4 of the Constitution. He has been a justice of the Supreme Court or a justice of the Superior Court for more than 30 years, more than 3 decades. There has been no incident of questionable acts of integrity on his part. Indeed, prior to coming for the bedroom, Mr. Speaker, the NIB, or the National Intelligence Bureau, or what we used to call BNI, did background checks on him, and the report came back with a clean bill of health. He is fully clean as far as his job as a justice of the Superior Court is concerned. So there are no questions to be raised when it comes to meeting the constitutional criteria. Mr. Speaker, we all know in this country that our judiciary is at a crossroads. That public trust is fast declining when it comes to the performance of the judiciary. Various studies, empirical studies have shown that that is the case. In that respect, Mr. Speaker, you need an experienced hand to steer the affairs of the judiciary and take us out of that storm. And the right person at this moment in time is no other than the person who has served the judiciary with distinction for over 3 decades. Mr. Speaker, when he answered the questions, you could see he did so with brilliance. You could see he did so from an experienced standpoint, someone who knows the judiciary outside out, and he is the person who will steer us out of the troubles that we are now facing in terms of the institutional performance of the judiciary. Mr. Speaker, what caught my eye as Attorney General and Minister of Justice on that day was when he was asked a question regarding how he was going to transform the judiciary. Mr. Speaker, I am sure the minority will do well to listen to what I'm going to say. Mr. Speaker, he gave us three cardinal pillars on which he is going to transform the judiciary. He said he is going to introduce rules relating to procedural clarity and flexibility. Second, he is going to introduce efficiency in justice delivery. And third, accountability at all levels of judicial decision making. This is what we need at this point in time in our history. This is what we need for the judiciary to be independent and to perform and deliver justice to the people of this country. Mr. Speaker, on the issue of pending suits, I am, or let me say my office is, a nominal defendant in all the suits. And I know better, looking at the Constitution and our standing orders, than to comment on pending suits before the courts of justice, whether it is the ECOWAS court or it is our own judiciary. But Mr. Speaker, I want to assure this House and all Ghanaians, our citizens who are listening to us, that nothing untoward, no untoward conduct has emanated from our office. And the minority, with all the experienced lawyers that we have, including but not limited to the Honorable Minority Leader himself, should know that if the Supreme Court comes out with its decision saying that the process of the removal of the Chief Justice was groundless, in other words, there was no ground, there were no legal grounds for the removal. Mr. Speaker, no, listen to this, listen to this. In order to say, the President of the Republic, His Excellency John Dramani, has no option but to obey the orders of the court. In fact, if he does not obey, the Constitution says that that's a high crime.
Honorable Minister, so Attorney General, this is an area that has been a direct reform. You have to move away from it, and let's focus on the matter before the House.
Thank you, Right Honorable Speaker.
My Lord Leader is on the feet, yes.
Speaker, with respect, my respected colleague, the learned Attorney General, made reference to me in his submissions. To the extent that I feel misquoted, I just want to take the opportunity to correct the fact on record. He contends that the minority, with all its lawyers, including me, have misconstrued the matters at the various courts, and goes on to make further submission that should there be any ruling in favor of the plaintiff, her ladyship, Justice Tokonu, Mr. President would obey. Mr. Speaker, the gravamen of my contention and that of my colleagues is to the effect that the learned Attorney General's office, with the time given to file defense in the suit, has failed to do so. That was the argument of bad faith we raised, that in ECOWAS court, there's a time, and if we really want to enrich our constitution and enrich democracy, that when a person appears before court, parties to the suit, however nominal, would make the abuse known. And Mr. Speaker, the learned Attorney General, by making inference to my submission, again says that he is merely a nominal. But as nominal as he is the only party that Constitution provides I want to file a defense. So it was his duty to take issues, traverse the markets, and Mr. Speaker, throughout the period, he did not, and it was the reason why we argued that, look, having failed to do that on time, you've created a certain lacuna, you've created a certain situation that goes against the rights of the respected former chief justice. That was the contention. I was not raising any other thing, but rightly saying that if you have failed on time, especially when you were set with all the processes on time, look at the way the injunction application was speedily held. The substantive matter was pending long before vacation, and even after legal vacation, you didn't file a defense. You later went to the court to file a process for leave for extension of time, to file your process out of time. Meanwhile, we were receiving a nomination. Meanwhile, government was again bound to hear the nominee. This was the argument we made, and it was not to attack the issue before the court. It was the action of your office, and that is why we raised it. So let us
we are ready. Please. I was compelled to give him time because you referred to it. And it's not a matter, as I read earlier on, that is of concern to the motion that is before the House. So kindly move away from there and then make your submissions. I'll definitely, I've taken note of the interjections and you have enough time to make your submission. Please, you may go on.
Mr. Speaker, thank you very much. There is a point of correction, and because we are a house of record, Mr. Speaker, I think it is very, very important. The Honorable Minority Leader himself knows very well that the rules of court, CI 16, supplemented by CI 47, the High Court Civil Procedure Rules, accords lawyers the opportunity to apply for extension to file their processes out of time. This is not something strange, and there is nothing sinister in what we have done. So, Mr. Speaker, in rounding up, I wish to employ all of you, my colleagues in this house, that we approve the president's nominee because he is ably and eminently qualified in terms of Article 128 clause 4 of the Constitution. He is one of the most experienced justices of the Supreme Court that we have. And his experience is definitely needed at this point in time in our history.
Yes, may we go to the next speaker now, and that is Honorable Tankuli Hassan. You have 7 minutes. Honorable member, please. I was trying to get the second deputy speaker. I just requested he's on an assignment. So then you can make it just 5 minutes. I'll be back and then you make your submission. Sitting is suspended for 5 minutes.